Good morning. Welcome to another edition of Legal Access brought to you by the McGuire Law Firm. Today we're going to be talking about criminal law. If you have any questions about DUI arrest, drug arrest, even traffic tickets, we can talk about that. The court system in general, plea bargains, bonds, bails, whatever you have a question about, we can talk about that all here today. Phone number is on your screen. Don't wait to the very end of the show to give us a call. So call now at 843-848-8080. Here on the panel to answer the questions for you today, both from the Chambers Law Firm is Trent Chambers, and also at the end of the table, for no specific reason, Tyler Silvestro. And we were going to have somebody from the solicitor's office here today, and we don't. So I take it that you guys will be fair as far as just having the defense side here represented and not the prosecution.
I used to be a prosecutor, so
and no promises, Ed.
That's all right.
All right, again, the phone line's open. If you have any questions about any aspect of criminal law or the court system or in general, we'd be happy to answer them for you here today. Now, since we got you guys here from the defense side, let me just go ahead and ask you, what is easier when you're at trial, to get one person to vote not guilty or to get 12 people to vote guilty?
you only need one.
So
Only need one.
defense is easier than prosecution?
Theoretically, yes. It certainly should be.
It depends on the case, of
Yeah.
course. Some of them are going to be much more difficult for the prosecution to prove.
Yeah.
And the defense really doesn't have to prove anything. They just have to poke holes in what
Right.
the prosecution puts out there.
Now, Trent, as you said, you worked with the prosecution before with the solicitor's office a few years back.
Yeah, it's been a while.
Now, since that time, and I don't know how many years ago that's been, obviously there's been improvements as far as, gathering evidence and the CSI effect and all the kind of things out there. Was it tough prosecuting back in the day, or do you think it's harder today when the juries demand to have some of that evidence that has to be, the DNA type stuff?
As a prosecutor back then, you didn't have to have everything.
Right.
You didn't have to have the video. It was nice if you did, but you didn't have to have it.
Right.
And then as time went on, juries expected you to have the videos and things like that. So times have changed, but as technology has changed as well. I mean, when I first did it, we had VHS tapes and we had magnets that we were erasing them with and then putting them back out in the officer's hands, that type thing. So it has changed a lot, and I think that's changed, and it's helped both sides, actually. The mandatory videotaping is actually.
From the other side of the equation, from the defense side, when you're looking at this, if the prosecution doesn't have ring camera, video, CCTV, or DNA, does that make it easier for you guys to defend if you don't have all that kind of evidence?
Absolutely.
Oh, it's interesting to think about with how prominent videos are now in these cases and the expectation of juries to have those, because it's so transparent, where prior you'd have witnesses describing things and attorneys trying to poke holes in that story or spin a witness in circles, or depending on how they described a certain interaction, that's all a jury had. Now a lot of times they have a front row seat to what happened, and that can be more helpful for either side depending on the case, of course, but it is an interesting change.
Now, as far as some of the things that are going on now with, where's I going to go on this? Okay. We know that whenever we talk to the solicitor's office, they always say that there's about 10,000 cases per year between Horry and Georgetown County, which is the 15th Circuit. But there's only 26 weeks of the year where you actually have court. So many of the cases, probably 95%, are done in plea bargains ahead of time. Do you guys as defense attorneys use that to your advantage, knowing that most of the cases are not going to be going to court?
We do. But as they have come up with a better system to streamline some cases, and some of the smaller cases get treated through transfer court and things like that, which has really opened up some more court time for the courts and the prosecution to try more cases. I have seen an uptick in the number of cases that the prosecution's able to try now than it has been in the past.
Yeah, the system, you would have to have so many judges, so many jury pools to be able to try all these cases. So plea bargains are to some extent a necessity. And again, of course, just like everything else and just like most answers you're going to get from an attorney, it depends, right? Yeah. Is it a benefit? Is it not? Depends on the case and the situation. But it is a necessary part of the process, just based on the structure of how much resources you need to be able to put on a case. And it's just not possible to try every case.
Well, one of the reasons that actually, I guess, jury trials are a little bit more speedy in the state of South Carolina is because we don't have a jury selection process where you go back, you have the voir dire, where you can ask all the questions of all the potential jurors. Do you think that that's a good thing or bad thing in the state of South Carolina?
I think it's an absolutely bad thing, for the defense especially. When I go to national seminars and we tell other lawyers from other states that we are handicapped in that way, they're appalled. How do you do that? You know, because they get to sit and have conversations with jurors for maybe a week on some cases, and just sit down like you're having coffee and talking with these folks. And we don't get any of that. We get to submit maybe 5 or 10 questions to a judge, and the judge gets to pick which 1 or 2 he asks, and that's all we get. So, yeah.
So is it an advantage to the defense or the prosecution to not have jury questioning?
I think it's a disadvantage to both. The prosecution, I mean, murder cases are a little different in South Carolina. You do get a little more time there, but it's nothing like you get in other states, absolutely.
I think it hampers both sides. It would just be helpful for both to have more information about who you may select on a jury. And it's also to keep in mind you're not actually so much selecting a jury as deselecting certain candidates as you go through. You're striking jurors, not saying, I want this person and cherry picking, but to have more information to figure out this person really might be a detriment to my client on my case.
Right.
To have more info and more time to be able to talk, and that would be very advantageous here. And I think that's more of a fair part of the process, and it's surprising that we have such a limited voir dire here, because as Trent said, there's so many other states have a very expansive process for that, and we just don't.
Oh, yeah. Tell you what, we're going to run to a break here real quick. When we get back, we would love to talk to you. If you have any questions about the criminal law system, whether it's the court system in general or something specific about a DUI or drug arrest or any other criminal arrest or ticket that you may have gotten, give us a call. The phone number's on your screen, 843-848-8080. Criminal law, that's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Today we're talking about criminal law. If you have any questions about any specifics like DUI, drug arrest, or even traffic tickets, or maybe just the court system in general, make sure and give us a call. Number's on your screen. Don't wait till the very end of the last segment to call in. We wanted you to call in now so we have plenty of time to get you on the air and answer your questions. Here to answer the questions for you today, both from the Chambers Law Firm, is Trent Chambers and Tyler Silvestro. I'm Dave Priest. I'm not answering questions. I'm just asking them. DUI, as I mentioned, is one of the aspects of criminal law, and obviously we usually have a show that's devoted specifically to DUI because there are a lot of aspects to it. But Trent, you were telling me before the show started that they're actually in Columbia, in the state legislature, they're actually looking at potentially changing some of the DUI laws in the state of South Carolina?
The Senate just unanimously passed a bill that went over to the House Judiciary Committee and onto the full House eventually, that really is an upheaval of what we have now. It's increased penalties, increased time for ignition interlock device, increased fines, increased jail time with penalties, creates a new tier of DUI.
Right.
It's what they're calling second degree DUI with moderate bodily injury.
Right.
Instead of a felony DUI, so there would be 3 tiers. You'd have your regular DUI, moderate bodily injury DUI, and then felony DUI as well, with increased penalties on all of those.
Right.
What else, Tyler? Was there other stuff involved?
The EMS blood draws.
Yeah, that was something that concerned me that I saw in that bill is EMS and EMT blood draws, phlebotomist blood draws at the scene, which goes against some of the law that we have now that says you have to have a warrant to draw blood. So we'll see where that goes.
Yeah.
You know?
Do you think that they're doing this to try to catch up a little bit? Because it wasn't too long ago, maybe a generation ago or less, that if a cop pulled you over and you looked like you had a little bit too much to drink, you'd be like, okay, well, you just be safe on your way home. Just get going there.
Yeah, that's changed a lot with litigation, things like that. Now the cop is liable if he, would let someone who's intoxicated leave, and then
Yeah.
they run into somebody, and then the McGuire law firm gets involved. Those type of things. So we don't see that anymore. With the videotapes and everything, that's
Right.
how everybody's accountable for everything they do. So.
Well, it's obviously changed, but like I said, it wasn't too long ago. You talked to somebody who's my generation or a little bit older, and they say, yeah, I remember I got pulled over and the cop just said, just be careful, you're only a half a block from your house. You'll be okay.
Yeah, heard that.
Days are over.
Oh,
I
yeah,
can tell
for
you
sure.
that.
Staying with DUI for just 1 second. Again, that's not our specific topic here today. We're talking about criminal law, so give us a call on the number on your screen. If you have any questions in general or specifically, please feel free to blow a call in to us, and we'll get you on the air. But speaking of DUI, now, since you guys are criminal defense, if somebody sees you and talks to you, whether it's at a concert or somewhere else, and they say, hey, if I get pulled over for DUI suspicion, should I take the breathalyzer? Should I do the roadside sobriety test, or should I just tell them, no, I'm not interested?
It is your absolute right to do neither one of those. You don't have to take the field sobriety test on the roadside, and you don't have to blow into the data master machine.
Right.
The first one does not come with consequences. If you refuse to do the roadside field sobriety test under the current law, you can't be charged with disobeying a police officer. A lawful command. They've asked you to do it, and you can refuse it. Most of the time they don't tell you that you can refuse it, but you can certainly do that, and typically they're going to place you under arrest right then and there,
Right.
and then take you in for this data master test, and they're going to read you your implied consent rights, which tells you you don't have to take this, but if you don't, we're going to suspend your license. Right. You're going to have to get an ignition interlock device, go to an ADSAP class, and to clear your license and get it back straight.
Right.
And there's a process, a due process that you can we have where you can request a hearing on that and get a temporary alcohol license during that time period.
Right.
While you're waiting for this hearing. So we do that quite often in our office. And then you've got the criminal side of it as well. So you've got 2 shots at your license when it comes to DUI.
Going back to what we were talking about, it was some of the new DUI laws. They're discussing potentially having a blood draw at the scene. Well, and I don't know how unique South Carolina is, but obviously, as far as the breathalyzer, as you said, the data master is not done at the scene. That's something you have to be taken back to the police station to have done. Why is South Carolina like that instead of doing it in the field?
I think it's a money issue, number one, and the state has to keep every machine that it uses. It has to be up to date, verified and in good working order, and
Right.
kept
Calibrated.
and maintained that way and calibrated. And we've seen that in other states where they have the roadside ones, and then a lot of cases got thrown out because those things weren't calibrated. They weren't properly maintained.
They're also not quite as accurate. It's similar to on a drug case where you have a field test, right? Field test kit. They still need to send those alleged drugs off to a lab to get a more accurate reading on what exactly, as far as weight amounts and percentages, to determine whether or not these drugs are what the state's alleging they are. I think it's somewhat similar in the roadside tests, that they're more used for probable cause, and they'd still want to have something a little bit more scientifically accurate after the fact to be able to bolster the state's case on that. And I think it is interesting, going back to what we said a moment ago about do you blow, do you not? To kind of walk through that, it is situational, because in South Carolina currently now, as of 2024, I think it was May 17th or 18th of 2024, when they enhanced the penalties for refusing to blow. As Trent said, we can request an administrative hearing, try to get you a temporary license, and try and fight that part of the case, but you will end up with a license suspension and some potential penalties that are almost equivalent to what a DUI conviction would be for just not blowing. And if you are at that point of being in the room with the data master to be able to blow, you're already under arrest. So at that point, the question is, do you want to give the state evidence that they're just going to use against you? Or do you want to refuse that test and hope that you can avoid those license suspensions that come with the refusal? It is difficult for us to say because the penalties are fairly substantial now. But I will say, in my opinion, if you've had a few drinks, it's usually best not to blow.
Right. And speaking of, not speaking of, but you mentioned drugs, but going to drugs for just 1 second. I remember talking to one of our former solicitor, and he said that, he's in the Senate right now, and he talked about, some of the legislation that was in the Senate a year or two ago as far as the legalization of marijuana in the state of South Carolina, as far as recreational use or at least medicinal use. And I think his response was, well, as long as federally it's a Schedule I drug, which it is right now, although they're talking about moving that potentially. So do you think that there's going to be any movement anytime soon as far as the state of South Carolina, as far as medicinal marijuana is concerned?
I think that the deschedule, or not descheduling, but rescheduling to Schedule III, which is supposed to happen, it's been mandated, and that is a slow process. I think it's going to be 2 to 3 years federally before it is actually done and completed. I think when that's done, you may see some changes in the law in South Carolina, but until that is completed at the federal level, I don't think it's going to change anything here.
I would say South Carolina is going to be one of the last states to really get behind that. They'll hold out as long as they can. That's what we've seen so far.
And we were talking about DUIs a second ago. Now, obviously, there's a lot of things that are consumable within the realm of, CBDs and things like that, THC, et cetera, that are available in South Carolina, whether they're legal or not. If somebody gets pulled over and they're under the influence, for example, or, how is that provable or not provable, or,
There's not a real threshold that you see, and there's nothing that's been laid out that, you can go and rely on other areas and other countries, really, and go with some sort of blood test. But there are arguments out there and experts that you can get that tell you, if somebody's tried marijuana for the first time, that their ability to drive a car is probably going to be messed up.
Yeah.
But somebody who's been using marijuana for 10 years, they're not going to have any effects on their driving. And there's studies that show that. So that's why we have jury trials, and we have witnesses that come in and the videos, and then a jury can decide whether or not that person's guilty or not. Were they impaired? That's why we have jury trials. But we don't have anything in South Carolina that says there is a limit that says, okay, you're under the influence. It's either positive or negative, and then a jury can determine whether that person's under the influence or not.
Now that's as far as driving is concerned. What about possession? I mean, if you're coming from a state where something is legal to be able to buy at a dispensary, and you come to South Carolina and you just happen to have some of that with you, are laws, or at least judges, starting to be a little bit more
I think it comes
nice about that?
I think it comes down to the prosecutors, yes. And I've seen that a lot of times where it's a small amount of marijuana. It's over the threshold for simple possession, but it's just over the threshold. And you're in general sessions with that charge, with possession over an ounce or possession with intent to distribute, and everybody looks at it and says, well, it's just marijuana. We'll move it down a level, and you can have maybe do some conditional discharge or something like that, make it go away.
It has been very interesting, actually, to see some of the stores around here that are selling under the hemp laws, right, under the Farm Bill. And we have seen quite a few issues. I've actually had cases recently where it is clearly labeled as being from a local store, and an officer still charged somebody for simple possession of marijuana, and that creates a nightmare. So that is also something to keep in mind. When you're dealing with criminal law, there's two aspects of this. There's whether or not you could be proven guilty at trial, beyond a reasonable doubt, and whether or not you're going to have to get arrested and get money together to hire somebody like Trent and myself to be able to defend you, even if we can get it dismissed over time. So just be careful with these kind of things, because it has caused some problems in the past. And
it all boils down to testing. What's labeled as THCA, which is out there and you can go buy as flour or as concentrates all over the place. Once it's decarboxylized and heated, how's it test then? And that's what the state does when they take the stuff into their possession. They go and test it. And how do they test it? Well, they heat it up. And if it tests after they heat it up, then it's illegal.
And the word of the day is decarboxylized, so use that at least one more time today. Tell you what, we're going to take a quick little break, and we'll be back in just 1 second. If you have any questions about anything that we've been talking about or anything under the realm of criminal law, give us a call. We'll get you on the air. We got one more segment left right here on Legal Access. It's Legal Access. We got about 5-6 minutes left, so if you have any last-minute questions to get in about criminal law, the phone number's on your screen. Don't waste any time. Give us a call right now. We'll get you on the air. Whether you have any questions about specific laws I don't know, whether it's drugs, DUI, etc., or just the court system in general, we'd love to get you on and answer those questions for you, along with Trent Chambers and Tyler Silvestro, both from the Chambers Law Firm. Tell you what. Juries, whenever you're in a jury trial, I watch a lot of crime TV, as we've determined here over the months and years. A lot of the people that they interview afterward, they'll say, okay, well, you know, I looked at the jury and I knew that the jury wasn't buying anything that I had to say. When you guys are looking at a jury as you're trying to lay out your case, do you try to read the jury to find out whether or not you're on the right track as far as your defense is concerned?
You always try. Whether that's
Does it work?
accurate or not, you know, I don't know.
It is actually very difficult, and I will say it never ceases to amaze me and sometimes surprise me what a jury will say or a juror will say to you after the case as to what points they stuck on.
Right.
And most of the time I've found it's not one of the main points that either the prosecution or defense was trying to portray. Right. And so it can be very difficult to read juries and what they stick on and find the most interesting or important. I've had them replay segments of videos over and over that both myself and the prosecutor are looking at each other going, why do they want to look at this again? Why is this important to them? So sometimes it can come as a surprise, but it can be difficult to read juries. You do your best, but you never really know what a jury's going to decide.
Do they seem to be more reactive to emotional kind of evidence, more so than actual evidence?
What you usually hear from attorneys, trial lawyers, is you're telling a story. You want the jury to be engaged. As soon as you're arguing the law or a lot of technicalities, you probably have a problem with your case, because it is more difficult for a lay person, a juror, to be able to kind of walk through a lot of those arguments. And that's why, for example, for the prosecution, motive. Motive never has to be proven. But if you can't explain a motive, a jury has a hard time understanding how that case is really put together and believing in the prosecutor's side. If we, on the other hand, can explain other motives or other possible, potential reasons for something happening that they can actually bite into and understand our story, you have a much better luck convincing a jury to believe in your side and your argument in that case.
As defense attorneys, if the prosecution has like only circumstantial evidence, if they don't have the smoking gun, etc., is it easier for you guys to blow holes in that case rather than having the hard evidence?
I would say yes, absolutely. The circumstantial is easier to talk around and talk about than something that you got a video of somebody hitting someone and it's like, you've got that. There's no really disputing that other than why it happened.
Right.
Again, going back to the video, I just find it so interesting. These days, if you're in a bar, there's a bar fight, right? Chances are the whole thing is on video and you're basically playing this for a jury and they're sitting there as if they were in the bar watching it happen and they're making a decision, where prior you'd just have some witnesses having to explain what happened and the jury trying to imagine what this might have looked like and what may have happened.
Tell you what, that's all the time that we have here for today. We appreciate you watching Legal Access, brought to you by the McGuire Law Firm. Next week when we get together, we'll be talking about family law. So if you have any questions about divorce, separations, custody, and things like that, that's all next week. In the meantime, we appreciate you being here along with Trent Chambers and Tyler Silvestro from the Chambers Law Firm. I'm Dave Priest. We'll see you again next Thursday right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently